right, so the B-22C forms. First, want to talk about what those forms are not. They are not a realistic calculation of the debtor's present ability to make a planned payment. The income portion of the form is the debtor's actual income in the 6 months prior to filing, which may have nothing to do with how much money they're making right now. The expense portion is partially IRS collection standards, which are not related to the debtor's actual expenses, and in part debt service that includes, for example, secured debt on luxury items that the debtor has chosen to retain that, well, back in the old days, we'd be objecting to that, but they're allowed to do that under the B-22 forms. What the B-22 is also not is fair. If you fill out the form as it is intended, or as I believe it is intended to be filled out, it can require your client to pay more than they can really afford, and not infrequently may require them to pay less than they can really afford to pay their creditors. The B-22 forms are also not an opportunity for creative thinking, and that is because of what they are. They are an attempt by the Rules Committee to put the various provisions in BAP-CPA that define applicable commitment period and best efforts for above median debtors into a usable format. If you go through that form, you can find statutory provisions, or in some cases, case law, that is behind those lines. I, in fact, have done that. And I think I may have handed this out at a prior seminar on this issue years ago. I don't know. I did not make copies because I'm not going to kill a tree. But if anybody wants this afterwards, just come up, give me your name and email, and I can send you a copy of it. So I'm going to do a quick overview of the form, what the different parts say, and then we're going to get into some common errors in completing the B-22 forms and some of the gray areas where there's not a fabulous answer on how to do things. So first, the 122C1 form is the income portion. Part 1 of that form is the income of the debtor and the debtor's spouse, whether or not the spouse is a co-debtor in the case or not, and that is the actual income they earned in the 6 months before filing the petition divided by 6. Part 2, you calculate if the debtor is above or below median income, so you know how to calculate deductions from the income. For the purpose of that section, you have to deduct out the part of a non-filing spouse's income that is not contributed to the support of the debtor or the debtor's dependents, because 10110A defines current monthly income as including only that part of the non-filing spouse's income, or frankly anybody's income, that is paid for the support of the debtor or the debtor's dependents. So the form in Part 1 has you include all of the non-filing spouse's income, and Part 2 allows you to adjust it to match how current monthly income is defined in 10110A. In Part 3, you calculate the commitment period. For a commitment period, at least my opinion, I don't know, Wendell may differ, you keep in the non-filing spouse's entire income, because 1325B3, which talks about commitment period, says I wrote this down wrong, says you use the current monthly income of the debtor and the debtor's spouse combined. So on one part, we're looking at the 10110A definition of current monthly income, and in the other, we're looking at the 1325B language, which tells us how to determine applicable commitment period. So that's why the Part 2 and Part 3 are going to have different results. So you can be below median in Part 2, but above median in Part 3. That's a situation where your client has to have a 60-month applicable commitment period, but doesn't have to use Part 2 of the form to figure out how much they have to pay unsecured creditors.
So one comment about what Diana's talking about. In summary, if you look at a 22C1 form, there are 3 parts, but it does 2 things. Part 1 is simply figuring out what the current monthly income is. You then take that information and figure out what expenses am I allowed to deduct from my current monthly income. That's part 2 of this form, which is codified in 1325B3. Then you go to part 4 of the form and figure out what's my commitment period. And again, you have to use the current monthly income that you calculated in part 1, but in the case of applicable commitment period, 1325B4 says you have to use the current monthly income of the debtor and the debtor's spouse combined. And so that's why in part 3, where you're calculating the commitment period, you are not taking a marital adjustment and backing out any of the spouse's income, because the code says you have to include the CMI of the debtor and the debtor's spouse combined. So 3 parts, but it's doing 2 things. What expenses do I get? Do I have to use the 707B2 expenses and therefore fill out 22C2, or do I not? And then what's my commitment period?
Right.
And let me throw in, I personally think the form should put the commitment period calculation after the first one, which calculates what is really the CMI for the household, as opposed to the CMI of the debtor, even though CMI of household isn't defined in the statute. Because I think it's easy to get confused, particularly for pro se filers, to see I get these deductions for my non-filing spouse, but now I'm back to using the number from above that, and it's not flowing naturally. And I've actually submitted a recommendation to the Rules Committee that be changed, and they've ignored me.
And in fact, back in the day, Form 22C used to be one form. There wasn't a C1 and C2. And back in the day, if my memory serves correctly, they had these calculations the way Wendell described.
Lined up.
They used CMI first, then they determined the commitment period, and then they determined what expenses you get. The form is now in reverse, for what it's worth.
So moving on to the 122C2 form, 3 parts. In the first one, you calculate deductions from income. Some of the lines are going to use IRS collection standards. Others, you will average out on a per month basis what the debtor is going to pay during the 60-month plan period for those particular expenses. Some of that will be debt service, some of it will be other things. And I'm sure you're all familiar with that. Part 2 determines the monthly disposable income. So you take your Form 1 income and minus your expenses, times the result by 60, and there's your guarantee to unsecured creditors. Part 3 is changes in income or expenses, basically your landing argument. You know, changes in income or expenses that are known or reasonably certain. So let's talk about some common errors. I think one of the biggest errors that I see is incorrectly calculating income for the 6 months prior to filing the petition. Part of that, I think, is we have a really hard time wrapping our head around the concept that that is what it is. It has nothing to do with what the debtor's making now. It can be completely different than Schedule I. It is. That's just what it is. Sometimes I think you need, sometimes I found, well, let me back up a little bit. If we see a discrepancy, if we have the debtor's current income and we have their pay advices, and both of those are showing us a higher income than the 122C, and there's not an obvious explanation. It's not a new job. It's the same job the debtor's already had. We don't know of any particular thing. There's been nothing disclosed that would show why the debtor was making less money during the last 6 months than they are expected to make now. It's a red flag, so we're going to start looking. One of the things we might be doing is crunching the numbers on those pay advices ourselves for that 6 month period, or asking for more pay advices. And sometimes we found out that, all those numbers weren't included. All of those pay advices weren't included. You don't want us to do that. And it is very helpful if you know that there's a reason why there's going to be a discrepancy there. Let us know if you can, because then we don't have to go digging in and maybe find other things you would rather that we did not find. Thoughts on the income? Okay, I will say when this first started, what was it, 2005?
Mm-hmm.
The question was, when we're looking at the income, what do we look at? Is it money that the debtor receives in the 6 months, or the money that the debtor earned in that 6-month period? I think Judge Shermer flipped the coin at one point and said, meh, let's do it with received. So that's how we've calculated it in our office since. I don't know that that's binding, but it's just an answer so that we have a standard going forward.
So the pay date, not the
Pay date, yes.
not the end of period.
Yeah, which is also a whole lot easier to calculate.
Yes.
At least I think.
I know for some of you who may have gotten an objection from me where you'll see I'll ask for the last pay advice dated in 1 month and the first pay advice dated in the next month. It's for that reason. I'm going to calculate it either way, and if there's a difference, I'll give the debtor the benefit of the doubt on it. But I want to know what the number is if I'm going to go to the step of making a 22C objection. I'm going to say, here's the number. So,
Yeah. And if you have pay advices that have the year-to-date on them, that is by far the easiest way to calculate, I think. Because with some debtors, I think they get double paychecks for different kinds of things. You'll if you start digging down into them, you'll find out that paychecks may come every 2 weeks, but
Then there's one extra.
yeah, but there's a discrepancy in the pay. There's another one out there that you didn't get because the numbers don't match up. So the year-to-dates are very, very helpful.
so the easiest month of the year to calculate CMI in is anyone?
July.
July.
Yeah.
Right?
You're right.
So that's my favorite month when I'm reviewing these
Yeah.
cases because I know for a fact what it is if I've got year to date.
The debtor only had one job during that
Well,
period.
all
Yes,
things
if we
know
being
that.
right.
That's
Yeah.
the
And well, we
problem.
know that's not the case.
Yeah, and then I've seen a few where the debtor has changed jobs during the 6-month period, and for somehow the pay advices from that old job just didn't get included. So that's I don't know what the process is in your office. I don't know who's responsible for it, but you need to make sure that they're all those pay advices are coming into the calculation.
And if you have the client who can't get them anymore because their relationship with their former employer is not very positive, I think you probably need to do some sort of estimating. That's probably the only thing you can do before you put it together. If it gets into a mess, once you've got a case filed, you could issue a subpoena to the former employer if you really wanted to. But you can probably back out some numbers from bank deposits if they had direct deposit, that kind of thing. So it can be very tedious, but it can be done to give them some evidence to look at. Figure out what their current tax rate looks like, and then figure out what those deductions look like, add those back in, and that's your estimate of the weekly pay. Anyway.
Yeah. So let's move on to marital adjustments. Because I think this actually counts as a gray area and common error. Talked about how 10110A defines current monthly income as the debtor's income and amounts that are regularly paid for the support of the debtor or the debtor's dependents. It does not actually include the spouse's income. It only includes the portion of the spouse's income that is regularly paid for the support of the debtor or the debtor's dependents. So the marital adjustments on the 122C1 form are backing out the parts of the non-filing spouse's income that don't do that don't support the debtor or the debtor's dependents. We'll see things taken out sometimes that clearly are not within those parameters. The mortgage payment. The non-filing spouse is the only person liable on the mortgage. Well, I'm going to take that mortgage payment out. Well, no, that's for the support of the debtor. The debtor lives in the house. Can't take that out. You
But
might,
isn't the flip side, I get the actual amount that's paid instead of whatever the designated amount is on the.
you always get the actual amount if the debtor's on the
The
debt.
problem is if I'm not liable, I have to override the full, if the debtor's not liable on.
That's a
that
gray
debt-
area. We'll get to that kind of stuff later. Let's stick to one topic for now. Sometimes there are things that you can take out that aren't taken out. Technically, the non-filing spouse's taxes are not paid for the support of the debtor unless for some reason they're having all the tax deducted from the non-filing spouse's paycheck and none from the debtor's and they file joint returns. But normally, if they're both deducting properly, that non-filing spouse's taxes could be adjusted out. I don't think it makes a whole lot of difference because you can take them out as an expense anyway and it doesn't count on the commitment period, but it gives you an idea of the type of things you should be looking at. Do you have comments on that, either of you?
Just on if you're going to take a marital adjustment, I would encourage you to be specific about what it is that you're deducting. And here's the one that I hate. Non-filing spouses credit cards. What does that even mean? For example, what if the non-filing spouse goes to the grocery store and buys groceries every week on his or her credit card and then pays it off at the end of the month? Clearly, use of a credit card in that way would not be deductible because that money's going towards the benefit of the household and the family. If what you really mean is, my spouse has payments on pre-existing credit card debt, their debt that they are servicing, well, I think that's deductible. So be specific in those deductions, but if they're just vague, then that just is, number one, just going to require us to ask about them and take more time at the 341 meeting and possibly result in an objection that wasn't warranted.
Hey, Joe, some of us get that, but a lot of us use software like Best Case, and I know it's like a 40-character limit in that field. It's so stupid.
Yeah, well,
gotta
then you
try to
attach
figure out a
an
way
Excel
to.
spreadsheet that says.
Well,
exceeds the-
whatever you do, my suggestion would be don't type in non-filing spouses credit cards on the line. Be a little as descriptive as you can. But look, if you need an extra page, file a little memo with it. There's space at the end. Find a way to tell us. Like Diana said, save us all the trouble of having to go through the misery of litigating this stuff if we don't have to, right? Give us the information.
You could say non-filing spouse's pre-petition debt service.
Well, you
That's-
can also use the boxes at the bottom of I and J for this kind of information.
Right,
Right.
yeah, good point.
Yes, thank you, Judge. So I'm seeing with greater frequency, spouses are keeping everything separate financially, like they have separate bank accounts, and they're not sharing their financials with each other. And so I'm seeing instances where a client is telling me, well, I'm not sure I can get my non-filing spouse's pay stubs. But this is what he's putting into our joint account every month. This is his contribution. What's your reaction to that? What if we just cannot get them?
Tricky. The code is what it is.
Yeah, I mean, I think unfortunately, when a person is not in bankruptcy, they are free to live their lives any way they wish. But I think if you come into bankruptcy court seeking a wonderful relief, you have obligations. And I think at that point, it's time to open up the books and lay it all out and say,
Well, but that's assuming that the debtor is culpable in the non-filing spouse's refusal to turn those over.
I think hopefully, number one, with a little encouragement, that information might be obtained. If it absolutely can't be, it won't impact what expenses the debtor is entitled to, right? Because only the portion of the spouse's income that's being contributed, which the debtor is aware of in your scenario, would be included, right?
That's what I'm saying is that what if
The one thing
take
we
it
would,
the opposite direction?
the one thing we wouldn't be able to calculate, though, for sure,
before.
under your scenario, is the commitment period
Right.
before, because we don't know what income is not being contributed. And the majority of courts have held that while it's not crystal clear, that commitment period requires inclusion of all of the non-filing spouse's gross income. So
Now, if
You know,
you're,
hopefully these cases are few and far between, but
you would hope that these are cases where they're clearly below median and maybe information from a tax return, if they dare to file jointly, will be included. And their tax preparer probably encourages them to file jointly at least. And then, but if they're on the line, my thesis about it is that you might simply concede that you've got a 5-year commitment period and use the numbers that you've got contributed as their spousal income and do your numbers accordingly. But if
Yeah.
you're conceding the 5 years, that's the actually really critical thing that the fight is about. It's the B4 line.
Yeah, Wendell's right, because if they're above median anyway, we're gonna back everything out other than what's contributed to the household expenses. So you could include only what's contributed to the household expenses as long as they're still above median. And then it doesn't matter. Is it right? Is it filled in as the code requires it to be filled in? No, but the result is the same.
And if there's a chance that you might get below the median number by getting information from him or her, maybe that might actually shake something loose from them. You're going to make me do this for 2 more years because you don't want me to see your pay stubs. That's an interesting relationship, I gotta say. But yeah, I've seen it. It's definitely a real life problem. And I don't think Congress cared in 2005.
There is that. All right. I think, well, I guess that's gray areas too. We'll get to that later. All right. All right, how about another common error is failing to average actual expenses or debt service that will be over the 60-month applicable commitment period. Something that comes up, where this comes up often is 401k or other retirement loan repayments. I don't know why, but usually those are something that are going to be paid off before the end of the 60 months. So the debtor has 2 years left on their 401k loan payments. Their payments are $200 a month. On the appropriate line of the 122C2 form, you don't put in $200. You put in 200 times 24 divided by 60, because you have to average that out over the life of the plan. Same thing with debt service, with your car payments. If you would happen to have a mortgage that's going to be, that is not extending beyond the life of the plan, that's going to be paid off during the plan. It's the total amount divided by 60 months. So for those kind of things, you need to be careful that you're just not glomming in the payment exactly as it is on the plan or on Schedule J or Schedule I, wherever it might happen to be. You need to make sure that you adjust it so that it's the average over the 60 months.
Well, yeah. And the other thing about secured debt now is that you're going to be seeing a lot more car loans that are much longer than 5 years. And, are you trying to cram them down into that 5-year period? And what happens then? We don't get that, right?
If you're cramming it down?
Well, I mean, on the means test, you're only getting the monthly payment at that point.
yeah, the means test is, the code is odd when it comes to calculating the secured debt deduction, because I believe it literally would require you to take the remaining amounts owed under the
That's
contract and divide that by 60.
Isn't it the payments that will come due during the?
Right.
I think, yeah,
term of the
I
plan?
think you're
That's-
right.
So what Wendell's saying is that if they have an
Yeah.
84-month car loan,
Right.
and you're under reporting that expense.
You're only taking 60
Right.
regular contract payments, but if you have to cram it down in the plan, you're going to be potentially paying a much larger amount than the means test is saying.
Correct.
So what do you do then?
Although,
So you get the difference over in line 33.
Yeah, I don't see that as a problem.
or, I don't know. You're not going to like this, but it's like, hey, you're getting the benefit of cramming this loan down. This is probably high interest loan, and let's hope to God that, the interest rate you pay during the plan goes down. So, that whole thing's going to go down so that it is beneficial to the debtor to cram down this higher interest rate car payment, but paying it through the plan and paying a lower interest rate. So you know what? You're getting a benefit. Who cares? The B-22 may require you to pay a little more, but you're getting a big old benefit by getting rid of all this interest. So do I feel sorry for you? No. I don't know. Okay. No, go ahead.
Well, I was just going to kind of jump into, and I don't want to get ahead of what might be on the list, but at the outset, Diana said, what the 22C is not, right? It's not always fair if strictly construed. It's, in most cases, not accurate as far as income and or expenses. So I guess that begs the question, what do we do then? If you have a client, and let's all assume that we don't disagree with any particular number that you've used in your 22C form, whether it be for income or all of the various expenses, but based on the debtor's income now and their reasonable expenses, they simply cannot pay the number that's produced by the 22C. So what do we do? Is the debtor just stuck?
You do a landing affidavit.
Yeah.
Well,
Maybe.
Well, I'm not going to get too much into the case law, but I just wanted to point out that the confirmation requirement in 1325B1, first of all, there's discretion on the trustee's part and that of an unsecured creditor on whether to even make this an issue, right? 1325B says if the trustee or holder of an allowed unsecured claim objects, then the disposable income test, and in the case of an above median debtor, 22C2 becomes an issue. So we might not even have to go into the 22C2 if your pay stubs have proven your income and your budget's reasonable, and you've given us the appropriate plan length. I personally don't see the utility in subjecting all of us to the misery that is 22C2. But let's assume we're getting there for some reason. Maybe your income has changed and it's higher now, or it's less now, but we're going to go through the calculation anyway. B1 says in order to get confirmation, the plan has to provide that all the debtors' projected disposable income is committed to the plan for unsecured creditors. The Bankruptcy Code doesn't define projected disposable income. It only defines disposable income, which is in 1325B2. And so a lot of the courts, including the 8th Circuit Court of Appeals in Coop versus Frederickson, and the United States Supreme Court in Hamilton versus Lanning, had to determine what does projected disposable income mean, because it only defines what disposable income is. And back in the day, there were courts that did the mechanical approach and just said, nope, disposable income is the 22C2 form, it's CMI minus certain expenses, whatever that number is, that's what you get times 60. But because it produces absurd results, and results that aren't fair or aren't realistic, other courts, including our 8th Circuit and the Supremes, said, no, we're going to take the forward-looking approach and say, the 22C2 is just a calculation of disposable income. Like Diana said, it is what it is. It's just a tool. But we don't have to go with that. And the 8th Circuit, for example, in Coop said that you can consider changes not only in the debtor's income, but also their expenses in Schedule J, to the extent they differ from those imposed in the standards. And then, of course, the Supreme Court said in Hamilton versus Lanning that if there's a change in the debtor's income that's known or virtually certain to be known, we can account for that. And the Supreme Court went so far as to say, look, BAP-CPA did not change the idea of projected disposable income. Before BAP-CPA, courts always had the discretion to take into account changes in income or expenses or the reality of a debtor's financial circumstances. And they said BAP-CPA didn't change that. So I look at 22C2 as something that you have to fill out. It's a tool, but it's not the end-all be-all. And I think the courts the upper courts have given the bankruptcy judges discretion to say, okay, that's what the form says, but you, the debtor's attorney, can say, Judge, here's how I want you to deviate from that, and here's why. And the court can decide. And I think if you're reasonable, we're going to be reasonable, and I think we can come to a result that everybody can live with, and one that doesn't always require going line by line and litigating all of these issues.
Yeah. And as Joe pointed out, we don't have to object. Best efforts, that provision applies if the trustee or an unsecured creditor objects. You don't have to raise the best efforts objection if you can convince me I shouldn't.
What about on your plan form where you talk about your guarantees to the unsecured creditors? Do you take that number that you got from your means test?
That's what it says.
And then you just try to explain that away?
Well, I think it depends on what number we're talking about, because you've got two boxes at the end for special circumstance and landing arguments, expenses and income reductions to those numbers. And that could, if everybody accepts your changes, then that may change your guarantee that you're putting into the plan.
As a follow-up to your question and what Wendell said, and we talked about this in our prep, as I said, the 8th Circuit and Coop and the Supremes and Lanning said, we can account for changes, and we're not stuck with the 22C, but they didn't really tell us how to account for the changes. Do we take the number in 22C2 and adjust it upward or downward, depending upon the changes that we're identifying as appropriate? Do we throw the whole 22C2 out and just go with I and J? I mean, because if that's the case, I wouldn't have objected in the first place. I'm okay with I and J. I'm not even going to raise the issue. So they say we can account for the changes, but they don't tell us how.
Right.
And so,
Joseph, there's two ways. This is a gray area, but I think there are two ways of looking at that in Lanning. So if you look at the form, you have
Part 2 and Part 3.
Yeah, in Part 2, you calculate your monthly disposable income in line 45. In Part 3, that's where you put your Lanning adjustments. The form does not recalculate a different monthly disposable income. It does not tell you to do any math. Lanning, the opinion, doesn't really tell us what to do if there has been a change in circumstances. So you can either look at this and say, oh, well, I'm going to do the math and deduct Part 3 from Part 2, and that's my new result. Or you just say, fine, I made a Lanning argument. I'm going to throw this whole thing out the window. Let's just look at Schedule I and J. That's how I look at it. Partly because, let's face it, this doesn't make a whole lot of sense. Why do I want to stick with this any longer than I have to? I'd rather look at I and J. I'd rather look at what the debtor's making now and what the debtor's spending now, and I would rather have the ability to say, no, you don't need to spend $800 a month on going to the movies. That's ridiculous. That's not your best efforts. Instead of picking at all these little different lines. So I don't know, maybe that's your vibe, maybe that's what you want to do, but I would think if you have a chance to say, let's throw out the B-22 by making a Lanning argument, that's I don't know, that's how I would go. So,
Carl, has the Southern District been doing, if you have a Lanning argument, do you throw out the results of the test, or do you do the micromanaging number?
The way we do it, it's kind of the best of both worlds for debtors. We use the B-22 expenses, as long as there's no objection from the debtor to that, the basis for deviation. And we use, the 122C2 expenses are usually higher.
yeah, I
Than what
think
people
you're right.
actually spend, so it's really a boon.
yeah, it's been my experience doing this for as long as I have, that in most cases, the 22C affords the debtor more expense deduction than they actually have. The only exception to that is if the debtor has, for example, a mortgage payment that exceeds the IRS standard, I know that it's the practice and has been for a long time that the debtor gets the greater of the actual mortgage payment or the standard. I can find a lot of cases that say the opposite of that, and that impose the standards for that which are in fact standards. In fact, the IRS Financial Analysis Handbook and their collection financial standards say the debtor gets the actual expense or the standard, whichever is less. In dicta, the Supreme Court in the ransom case actually discussed a scenario under which the debtor's actual expense, national or local standard, is less than the standard. And while that wasn't the issue, they said the debtor would get less. It's in the opinion. And so there is authority for that proposition out there.
There's also, I believe, somewhere in the statute, and I know Joe knows this, where it talks about applicable expenses. So there may be a line in here or a standard that you get, but it's not applicable to that debtor. So a debtor who's couch surfing at somebody's house and has no rent or mortgage payment, well, that rent or mortgage expense, that's not applicable to them. They don't have it. We could actually make an argument that that comes back out, that they don't get that part of it.
And I'm sorry.
Which is, I guess, and we don't do that very often. But
That doesn't work for 5 years.
Right.
Most people
Yeah.
get sick and tired
Yeah.
of the couch surfing.
no, I know, but they,
So-
yeah.
Well-
But the point is that's why I just prefer to go with the Schedule J expenses, with what the debtor's actually spending as opposed to this construct.
And the issue Diana's talking about is the ransom case. You'll recall that's a case where the debtor owned a car free and clear but wanted to take the IRS transportation ownership expense deduction. And the Supreme Court, when it was interpreting 707B, particularly the provision that said the debtor's expenses are the applicable national and local standards, blah, 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 they focused on the word applicable. And they said if a debtor does not have the underlying debt for that type of expense, then that deduction is not applicable to them, and they don't get it. And then, again, when they were addressing arguments from the parties, they did address the issue of, well, what about if the debtor does have the expense, but the actual amount is less than the standard? And that wasn't the issue, but again, in dicta, you'll find it. They stated that you get the lesser.
So go out and get a $100 Title Max loan right before final? Oh, but I can't advise my client to do that.
Well,
That never happens.
If you follow the logic of the Supreme Court in their dicta, they would get $100. They wouldn't get the full IRS ownership deduction. They'd get their actual because it's less than that. And like Diana said, we generally don't enforce that. But I keep that in mind if you're at the end of 22C2 claiming all of these special circumstances deductions. I'm going to go back and say, well, wait a minute. You want $300 for dance lessons, but you got $400 of your IRS ownership expense that you're not currently using. And so why couldn't you, at least for the time being, move the money from there to there? Wendell brought up, well, but if somebody is couch surfing and they don't currently have a mortgage or rent payment, that's likely not going to be the case for the full 5 years. And I would agree with that. But the Supreme Court addressed that issue as well and said, well, that's what 1329 is for. If and when your circumstances change and you now have a housing expense that you didn't have, file a motion to modify the plan to account for that. So, just saying.
Since we're talking about Lanning, another common error is forgetting that Lanning goes both ways. So, woohoo! Mr. Debtor is now making $1,000 a month less than he was during the applicable commitment period. I'm putting $1,000 a month in the Lanning line in the 22C2 form. That's great. Mrs. Debtor's making $2,000 more. That gets reported as well. So it's the total. If you're going to be making a Lanning income argument, look at the total gross income on Schedule I and compare that to your 122C1 form. If the difference is minuscule, it's not going to fly. We're looking at the whole package. And we can also we can make a reverse Lanning argument. You may do a B-22 form that comes out with a big fat Easter egg to unsecured creditors, but we can tell that the debtor's making a whole lot more money now. We can make a leaning argument and argue that we're not going with that Easter egg. We want to look at Schedule I and J. We want to look at the way things are now and determine how much the plan payment should be.
Yeah, you should, your number at the end of J should have some relation to what you're going to be paying into the plan. I'm not sure that that creates a guarantee.
No, I don't think that, no.
But it means that you're paying a higher dividend than B-22 says you can, and I'm okay with that at the start of a plan because I don't have that many clients who go 5 years without something coming up and needing to change things, and in my mind, that builds up a little bit of cushion for the downward payment changes that are almost inevitable to come up, because no one goes through 5 years without some disaster happening to them these days.
Yeah, and I think a phrase Joe used when we were prepping is pigs get fat, hogs get slaughtered. If we're reviewing a case and we've got a 22C form that shows no guarantee to unsecured creditors or a tiny guarantee to unsecured creditors, and Schedule I and J show that the debtor is retaining, $1,500 a month unallocated income, little red flags go off, and we're going to be going through that with a fine-tooth comb trying to figure out why. Why is this happening? What's going on? This doesn't make sense. So, is there a reverse landing argument? Has the 22C been filled out incorrectly? Why is this happening? You are asking for an intense scrutiny of that case.
Unless it's Social Security or
right, unless it's Social Security.
Veterans
Yeah, that's
disability,
an
something
obvious.
like that.
Right. Obviously, yes, only the stuff that counts. But, we do see cases like this, and then you have to wonder why. Why is this? What's going on? Why are we seeing this? So
it's weird. I and J and B-22 really don't have anything to do with each other, and yet you kind of have to compare them.
Yeah. Does
Does your take-home pay look something like what after all the regular deductions? Is there some? Does it make sense? And if you aren't comparing those two things on a fairly regular basis, sometimes the B-22, when you're working on it, will look crazy because it says you've got $2,000 left over, and you're looking at your J and there's no money, and you can't figure out why, and that's where you actually find you've made a mistake in the math, hopefully, or it's something going on that goes in the special circumstance or landing lines, and it's something you don't have much control over, but it's not showing up initially.
follow up on what Wendell just said, keep in mind I and J and 22C2 are calculating two different things, right? I minus J is simply saying this is how much money I have to pay to all of my creditors by way of a planned payment to the trustee, whereas 22C2 is calculating how much money I have to pay to just the non-priority unsecureds, which is why in the 22C2 you have to deduct out all the amounts that are being paid to the priority creditors, to the secured creditors. So if you find yourself with a 22C2 that says you have to pay X number of dollars to the unsecureds, and you've proposed a plan with a planned payment based on I and J, and that plan will not pay the amount to unsecureds that the form says, a quick, easy way to kind of compare the two, to try to equate I and J to 22C2 to see where the differences might lie, is take your secured debt deduction from 22C2 and add it to your J. Take your secured claim deductions that are in your 22C2, add it to J.
Right.
Now you see what should be left for just the non-priority unsecureds. And if that number is different from 22C2 in a significant way, you've eliminated secured debt and priority debt as the culprit. So what else am I deducting in J that perhaps I'm not permitted in 22C2? Or what didn't I deduct in 22C2 that I can take? But that's a quick, easy way to say, I've got J, take out secureds, take out priority. This is what I should have for general uns. Why is my 22C2 showing a different number?
yeah, it is not uncommon when reviewing cases at the 341 stage to see a 22C that has a guarantee, and I don't think it really should be there. I'm not going to complain because your plan has a guarantee in it, but that there were omissions in that 22C form, expenses that weren't taken, errors that were made that resulted in a guarantee that was higher than it needed to be and wasn't caught and got carried over and put into the plan. So I think there is a need for some review of that.
You had a question?
Yeah.
What are, just because I might be guilty of something like that, what are some of the expenses that are overlooked often?
It could be anything, and my guess is some of it might be best case stuff, software stuff, because it'll be things that are just like left out, not put in.
It's actually kind of useful to once in a while from the debtor side to print this stupid thing out and read it line by line just once through, because we never actually see these forms. I mean, not really see them. We're looking at the screen, our data input screens on Best Case or now Jubilee, and they're like 3 words. And there's a long sentence in here that describes what you're supposed to be putting in. And sometimes it's just easy to skip past some things. That happens. And sometimes it's, if you're looking at your J and there is a significance, even after adding back in the debt service, it'll be stuff like what Joe and I were talking about. It'll be something where you might beg to vary from the allowance for like operating expense because of gas prices or something like that. And you just have to figure out what the differences are between your J and what's showing up here and why those numbers are different and whether it's worth arguing for.
Yeah. I'm going to put together some of the common errors that I think tie in with this are not being familiar with the law underlying the form, because all of these lines are based on something in the code, or most of them are based on something in the code, and not looking beyond the headings for each line when you fill it in. I think people see a heading and think, ooh, I can claim that, and you throw something in. Like Wendell said, you didn't read it. You don't know what it all says. That doesn't work. One of my favorite examples is there's something in there about funds paid for protection against family violence. Well, it refers to a specific code section, not a bankruptcy code section, some other federal code section out there that you have to qualify under if you're going to make those deductions. Every time I see that, I object and ask for proof. And every time I've made that objection, that expense has gone away in an amended 22C because nobody bothered reading that. They just thought it sounded like a good thing, like, oh, I pay for an alarm service for my house, I'm just going to throw that in there. That's not what it is. So you have to know what these lines say. You have to know what they mean so that you know what you can put into them. Another error kind of related to that is getting creative with deductions, trying to use the lines in ways they were not intended, rather than just making a special circumstance or a landing argument, like Wendell said. If you have something that is out of the box, I think there's a pretty good chance you can cram it into one of those two. Not everything. Some things are, or I think set. Tuition for children. I think that is one of those. Congress has put limits on that, very specific limits. A set dollar amount for...
But maybe room and board might go in.
It might.
Well, if it's court ordered.
It might. If it's court ordered.
It's a domestic
Well, that's
support,
domestic
it's the full
support.
amount.
Domestic support, yeah. But otherwise, under 18 or under high school, it's limited to a certain dollar amount per child, and college tuition isn't even in there.
Yeah, I mean, like it or not, that was the policy decision that was made, and it's codified. But and the way I would look at that kind of expense too is if you are otherwise in compliance and are in fact fairly frugal in your budget, and that's the only issue I've identified, I can choose to not object if I don't want to raise that issue. So it would behoove you, if you have someone who has one of these expenses that are not expressly allowed, to encourage the debtor to maybe tighten the belt in other areas a little bit, to perhaps avoid an objection on that issue.
Yeah. And as Carl pointed out, sometimes the deductions in here, the expense deductions, are quite generous to the debtor. So let's say your debtor is paying some amount of money per month for college tuition. You can't fill it in on that form, but maybe it doesn't matter because the fact that it's in Schedule J, that's not the B-22, right? If the B-22 comes up with a number, I can't make a best efforts objection based on Schedule J, or I don't know that I can. If the debtor's meeting what Congress said they had to meet for best efforts. So the fact that they're actually paying it, if they're not trying to claim it in here, I don't think I have a very good objection. I think I'd have a hard time winning.
Yeah, sometimes, one comment and then a question, but sometimes if somebody, for example, has a second, one debtor paying for 2 cars, if you only take a deduction for 1 car in the 22C2, then I don't have a problem with that because the number that you're going to be paying to your general UNS is based on you paying for only 1 car. Perhaps you're finding the money to pay for the other car somewhere in the budget, especially if there's some Social Security income or some VA disability income that is off the table to begin with, then it doesn't matter. So, again, I measure certain deductions based on other money that's available in the budget to cover those. So,
All right, question, then we have like 5 minutes.
My panel's almost out of time, but I was like to ask if you can explain the difference between lines 33 and 34, because that form has 2 lines on payments for secured debt. One is your care and maintain, that's your 34. The other one is your catch-all 33. And in particular, line 34 is limited only to items that are necessary for the maintenance and support of the debtor, whereas line 33 doesn't have that same language.
I think isn't 33 where you carry over
It's the overflow.
It's the overflow. You've already claimed that on the mortgages and
What if I
the
got an
cars.
EV?
you got what?
Like, what if I have something other than
David,
a
let me
car
let
or a
me finish.
Sorry.
I think line 33 is where you pull in the debt service that you have already inserted earlier in the form and deducted from the standards. So that's where you get to claim it back in so that you get it. And line 34 is for your other secured debt service, those that were not claimed. These lines, correct me if I'm wrong, but these lines they tell you to copy line 9B, 13B, 13E. So these are specific things that you have already taken in the form that they're bringing back in so that the math works. That's why there's 2 different sections.
This is like if I have a furniture loan, for instance.
It will go in 34.
34.
Right. So 33 is for mortgage, auto loan. What if you had, for example, I don't know, a roofing loan? I don't know, any kind of
Timeshare.
No, only the ones that you have deducted in those referenced lines, right? Oh no, okay, you do have the 33D other secured debt.
Right,
Okay.
right, right. So if you have any secured debt on your house, a judgment lien that you have to pay for example, okay, clearly that's not a mortgage, right? But it is another secured debt. I think 34 is where you would deduct that secured debt, and 33 is where you're simply carrying over the mortgage secured debt from earlier in the form. Does that make sense?
And it
I
probably
understand what you're saying, yes.
it probably auto-populates with your software.
Yeah, it does.
Yeah.
And
So you're not able to cram something into the overflow line.
And to answer your other question, which is, and I'm only speculating here, but why does 34 have attached to it the phrase that's necessary for your support or the support of your dependents? Because what if this is a secured debt and the property that secures it is not necessary? For example, what if it's a boat?
Or a timeshare.
Okay,
Timeshares,
you've deducted your secured debt payment on the boat in 33D, other secured debts, right? Or whatever, or earlier in the form, wherever it is. Is that necessary for the debtor's maintenance or support? I don't know. Maybe that's why that is qualified there. That we're going to give you the opportunity to deduct secured debts other than your home and your car as long as they're necessary and reasonable.
Because there is a reasonable qualification in 707, right?
Yeah, 1325. So the actual definition or formula for calculating disposable income, remember, not projected, that's 1325B1, but B2 talks about disposable income, CMI minus reasonably necessary expenses. And for those people whose annualized current monthly income exceeds the household income, they have to use 707B2 as their expenses. But the point is, the term reasonably necessary is still in the code. CMI minus reasonably necessary. And so the question is, for those people who are above median and have to use 707B expenses, which include secured debts, do they get all of their secured debts, even if they're unreasonable? Or are they limited to secured debts that are reasonable? So an outlandish example would be somebody who's filing Chapter 13. They have their car, they have their house, and they've got a $200,000 yacht that they keep at the Lake of the Ozarks. The payment's $2,000 a month. They want to keep it. They want to pay their unsecureds nothing. They're above median. The code says that, well, you get 707B expenses, which include your secured debt payments. But it also says reasonably necessary. So I would argue that even above median debtors have to adhere to the reasonably necessary standard for their secured debts. And I think I would have a legal basis to say, no, I'm not telling you whether to keep the yacht or not. What I'm saying is you don't get to deduct the payment for it when we calculate your disposable income.
And that is one of the gray areas in interpreting the 22C forms.
So if I'm hearing you correctly on that, the point would be not to take that luxury accessory on the B-22. It can go in your plan as long as it doesn't affect your guarantee.
Yeah.
And if they can still
Okay.
afford it.
Show of hands, who thinks they could successfully make a 13 work for a debtor with a $200,000 yacht?
No,
Okay,
no.
just saying.
Let's just say that if you do deduct it in the 22C, and you're going to get an objection.
See, and this
What about
is
a $20,000 boat?
this is discriminatory because if I've got a $10,000 Harley, probably I'm going to get to hang on to it. But the yacht, no.
People like their Harleys better than their children, you know that.
Well, yes.
Well, I could, again, we all have a little discretion in this process. And so maybe in Wendell's case, all other things being equal, maybe I don't object. I don't know.